Okay, good afternoon, everyone. Welcome to this interesting session on the private non-personal data and the proposed regulations in respect of private non-personal data and the commercial implications of such regulations. Now, the topic is interesting, not because of this discussion today, but it raises a lot of questions on what is ownership of data, what kind of data is possible to be exploited. And when I say possible to be exploited, not just from a technical or commercial perspective, even from a legal ownership perspective, what kind of data should be allowed to be exploited, what kind of data should be able or should be capable of being used by others when it belongs to a particular individual. What is the relationship between data and a person, even if it is non-private? And what is the relationship between data and anybody who wants to commercially utilize this data? I know there are a lot of phrases that are thrown about in connection with data. It's a new oil, it's a question of sovereignty, and lots of other things. And I believe that it's many of those are mistaken phrases, and fundamentally do not look at the relationship between a person and the data and how such data arises, right? And why does a person carry out certain activities because of which the data arises, and what is the relationship that leads to the generation of the data, maintenance of data, and later on utilization of the data. So my job today is very simple and easy. Actually, I'll just introduce you to Rohan, who is the expert on this. Rohan will do most of the talking, and then I will pitch in only if there are some points I believe need to be discussed or make a few comments towards the end of the session. So over to you, Rohan.
Thank you, Harish. Yeah, thank you for the succinct introduction to the kind of issues we are looking at here as far as non-personal data is concerned. I think it's fair to say that prior to sometime, mid to late last year, even the phrase non-personal data was not really on a lot of people's lips. It's a fairly new development. And let me just walk you through a little bit about the non-personal data framework. Harish, could you please enable screen sharing on my screen? Then I will be able to walk the participants through a very brief introduction to non-personal data and the framework.
Sure.
In the meantime, thank you. In the meantime, let me just walk you through a little bit of the background here. The Personal Data Protection Justice Sri Krishna Committee report mentioned very clearly, and the draft Personal Data Protection Bill also mentioned very clearly, that it does not seek to regulate within its ambit data which may be considered to be non-personal data, that is not pertaining to a natural person. Of course, it did recommend a law to protect the data privacy rights of communities, which it understood as being a very important element of data privacy, which is not addressed in an individual data privacy legislation. At the same time, and from a very different direction, it's worth noting that there have been calls from the government and from various functionaries of the government, sometimes speaking in their own capacity maybe, to break up big tech and allow the sale of data in order to ensure that it is available to a larger group of people. This all came to a head somewhere in September 16, 2019. One second, let me just make this available for you. Yes. So in September 16, 2019, the government actually constituted a committee to look at guidelines for the governance of non-personal data. This committee was headed by the ex-founder, co-founder of Infosys, Chris Gopalakrishnan, and was often called the Gopalakrishnan Committee. On July 7th, 2020, the Framework Committee report was released, and it sought to put forward a framework for the regulation of non-personal data. What this report sought to do at the outset was classify a very large and very amorphous body of data, which was referred to as non-personal data, and attempt to create a framework by which it would be shared basically through the country. In other words, I think, at least at the very outset, it's worth pointing out that the primary focus of this legislation is determining a mechanism by which data can be shared, of course, with the public by the government, and also data of private companies has a mechanism by which it can be effectively redistributed. That's the upshot of the legislation, I mean, of the framework report. And I'll walk you through how this is supposed to operate. Let's first understand the concept of non-personal data as per the report. Under the report, non-personal data is actually defined as data that is not personal data or data which is without personally identifiable information. This is, of course, a bit of a problem because it's effectively, defining non-personal data by its negative space, essentially, by referring to something which is not personal data and saying whatever is not in that box is non-personal data. This, of course, takes into account an incredibly wide and diverse set of databases and data sets, data points. And that is, of course, one of the initial concerns with the report, which is that in terms of the concept underlying non-personal data, perhaps there needs to be more analysis from a granularity perspective. So non-personal data is understood to be data that never related to natural persons. That is, it could be weather data, it could be pure geospatial data which is not involved with inhabited places. It could be data relating to certain specific phenomenon of seismological nature. So it could be data relating to purely natural phenomena, which doesn't directly apply to natural persons. But there are qualifications for even that, and I'll walk into that later on. It also relates to personal data that has been anonymized. The report is candid in that it acknowledges the fact that it is a function of time and technology and effort, essentially, to anonymize, to de-anonymize virtually any kind of anonymized personal data. But the report at least recommends certain protocols by which anonymization might be achieved. Again, before I step in, I'd like to point out at least something which I feel is important regarding this data, which is that, regarding this report, which is that while the report seeks to create a legal and regulatory framework for dealing with non-personal data, it does not really get into the legal foundations of non-personal data. It doesn't get into the legal foundations for a case for sharing non-personal data. And the emphasis seems to be more on the technical infrastructure and the technical architecture required to enable such a framework, rather than an actual analysis of the legal foundations for very important concepts such as community non-personal data, which I'll get into in some more detail. So again, as I mentioned earlier, non-personal data is defined and then categorized very broadly into three categories. One is public non-personal data, which is non-personal data collected by or under the aegis of the government, and which pertains to data sets which could relate to any number of different kinds of government collected information. The second category of non-personal data is private non-personal data, and that pertains to non-personal data that has been created by private entities, organizations, or individuals, and data sets which have been generated as a result of that. Again, I'll walk you through that in a little more detail as to what is not necessarily considered non-personal data, private non-personal data. For example, algorithms and such like, the actual underlying algorithms resulting in the processing of the data are not part of private non-personal data. And finally, you have something called community non-personal data, which is actually a subset of both public and private non-personal data. community non-personal data is a data pertaining to where a community of persons is either the source or the subject of that data. Again, it's a nebulous and very complex concept, and we'll get into a little more detail as we go along. In addition to that, the report recognizes the fact that there is a need to identify sensitive non-personal data. That is, the data which, for reasons of either national security or reasons of the fact that the personal data from which it had been collected was already of the nature of sensitive data as per the Personal Data Protection Bill, or for other reasons, it would be considered to be sensitive non-personal data. And that is treated differently. At least as far as personal data is concerned, the recommendation of the committee was that sensitive non-personal data needs to inherit that particular tag from the source personal data. So if you have a large data set of anonymized, let's say, diabetes test data, for example, that would be considered sensitive non-personal data, just as any individual test data report belonging to an individual would be considered to be sensitive personal data of that individual. So yes, as I mentioned earlier, one of the important concepts which needs to be understood here is community non-personal data. A community is considered to be any group of people which is bound by common interests and purposes and involved in a social or economic interaction. So this doesn't necessarily mean that the community has to be a geographical community. It doesn't have to be a cultural community. It could be a community that lives entirely online. It basically has to be a group of people bound by common interests and purposes and involved in social or economic interactions. Basically, any non-personal data whose source or subject pertains to a community of persons is considered to be community non-personal data. And one of the recommendations of the Gopalakrishnan Committee report is that raw data sets comprising anonymized information, which is collected by these private companies, can also be community non-personal data. This, as I'm sure a lot of you appreciate, raises a bunch of questions. Virtually any kind of data pertaining to groups of people contains within it at least some form of community non-personal data set. And differentiating between what is community non-personal data and what is not community non-personal data is going to be a complex, onerous, and possibly futile undertaking. Because, I mean, one of the clarifications provided is that, and by way of example, is that a company which would take drone video and analyze the same of, let's say, a small agricultural community and examine the agricultural the crop rearing patterns and examine the soil fertility using sensitive equipment. The data which should be derived from that would be considered to be community data. It's an example to specifically provided for in the report, and then it raises the question of what kind of data which ever pertains to any group of people or any data set pertaining to natural persons would not fall within the definition of community data. It's clear that examples like ride-sharing data or data pertaining to telecommunications is within the scope of community data. So, in other words, the scope of community data, non-personal data, is quite broad, and identifying a discrete community non-personal data set is going to be a complex undertaking. So I'd say one of the issues which would arise here would be understanding, defining, and responding to the concept of community non-personal data. At this particular point, I should have mentioned this at the very outset. September 13th is the deadline for responding to the Gopalakrishnan Committee report's findings. And I would strongly recommend that all of you who have a look and see something which is of relevance to from this or any other discussion you've heard, put forth your views, because I believe that this report could do with a lot of useful input in order to fine-tune the recommendations and findings therein.
Ron, pretty much anything can become community non-personal data, right?
Effectively, Harish, that is a major concern, because as we move through the report, we understand, as I mentioned earlier, that the primary focus is to create a legislative framework for nationalizing datasets. And one of the concerns that has raised within the report itself is that once you create this nationalized distributed data set system, there are specific communities whose data will become very apparent by just by algorithmic crunching. And on the one hand, there is a strong reason and concern to ensure that that kind of data is not misused or not capable of exploitation, and the committee acknowledges this and sees it as well. On the other hand, given the fact that one of the primary focuses is nationalization, a huge concern is to ensure that any companies, any data business, as is defined in the report, does not have basically their entire data set acquired simply due to the fact that their data can be considered to be community data. So that is something which needs to be fine-tuned in a significant way. Moving on from there, let's take a look at some of the fundamental concepts envisaged under the NPD framework. Again, the NPD framework provides a series of recommendations which it puts forward as far as a legislation or a mechanism for data sharing would be concerned. I have refrained from going recommendation by recommendation because it's easier to understand the entirety of the NPD framework's ambit by seeing it from the perspective of a potential legislation and how it would play out, or how it would be drafted, basically. So under an NPD framework legislation, these are the actors you'd begin by encountering. The first is the data principle. This is a concept which has now become a little familiar to those of us who have dealt with privacy law and the potential PDP bill and the pending PDP bill. The data principle is a little more complex also in that it is the entity to whom the data relates. Of course, in certain cases, the data could be purely algorithmically generated data created by a company, in which case the data principle would be the company which owns that data. If it is non-personal data pertaining to an individual, which is anonymized data pertaining to an individual, then the data principle becomes the individual who handed over that anonymized data. It's interesting to note here at this particular point that aside from the fact that the data principle is required to consent to the anonymization of their personal data, they're not required to consent. Their consent is required to be sought for the anonymization of such data. But aside from that, data principle's role in the overall framework is limited. It's important to note, though, that in the context of community data, the community as a whole is considered to be the data principle of its community data. And how that mechanism is implemented is something we'll walk through. The second person or the second actor is the data custodian. So again, we have language which is very broadly similar to that of the PDP bill. You have a data principal, you have the data fiduciary / custodian, a person who has been entrusted, so to speak, with collecting and processing the data in the best interest of the data principal. The data custodian is most often the entity which receives the non-personal data, which has created the data set, which is basically the entity which has created the database around which the data is to be the underlying database. Yes. The third actor involved is a data trustee, and this is a concept which is relevant specifically in the context of community data, because a data trustee is supposed to be an entity who will exercise rights over community data on behalf of that community. Now, this is again for the simple reason that community data itself is an inherently complex concept. The identification of a specific community is an equally complex concept, and identifying the actual data custodian in this context is going to be a complex, data trustee is going to be a complex undertaking. To that end, the report has recommended that in certain cases, the government would be the data trustee. For example, for all diabetes related, for example, health data collected nationally, the custodian would be the Ministry of Health and Family Welfare. for data relating to literacy or student passing rates and such like in a particular school or district, it would be considered to be the district collector. This concept of a data trustee and a person who's the custodian of a community's data, actually, I mean, as a personal observation, it bears some similarity to the idea of geographical indications to me as an intellectual property lawyer. Those are a form of intellectual property right, which generally are owned by a group or community of people. And very often in the context of geographical indication registration, there are debates or arguments even between different groups within the community as to who is the entity that is entitled to exercise rights over such data. So I anticipate this also as being an issue which will need some significant amount of rethinking and maybe a lot more granularity in how an entity will be considered to be a data trustee of an entire community's data. Finally, you have the concept of a data trust. A data trust is considered to be the institutional and technical structure which allows the data collection and sharing mechanism to occur. Of course, we need to understand the data collection and sharing mechanism first, and I'll explain that. But at the outset, the data trust is supposed to be the underlying structure from which metadata and data, non-personal data, may be extracted based on the terms of the data trust itself. Moving on from there, let's just have a broad look at the context behind this and understand very clearly what exactly this NPD framework is for. I think this quotation from the framework report is helpful. And I mean, like I could talk about it for a while, but this sort of summarizes the primary focus. Market transactions and market forces on their own will not bring about the maximum social and economic benefits from data for the society. Appropriate institutional and regulatory structures are essential for a thriving data economy and a well-functioning data society. The committee's approach to regulating data keeps such an understanding of data at its core. So, whatever other mechanisms or whatever other ways there are of explaining this framework report, to me, it appears to be clear that this is a mechanism for creating either a nationalization or a compulsory licensing regime for non-personal data sets. And that is the lens through which I think, the primary lens through which I think it can be viewed. There is, of course, a lot of provisions which pertain to, or a lot of recommendations which pertain to community data and data protection and data privacy, but the core mechanism and the core architecture seems to be built around enabling this mechanism, creating an appropriate institutional regulatory structure in order to create a redistributed data society or data economy. So let's look at the report's justification for NPD regulation in India. At the outset, the report acknowledges that data is clearly an asset. It's something which has been debated to some extent or the other in the context of intellectual property. Of course, it's always been acknowledged as an asset, but the nature of data as intellectual property is something which has always been taken back and forth. But the NPD report recommends the acknowledgement of data as an asset. Of course, it doesn't get into the question of the underlying intellectual property rights underlying data. It doesn't necessarily actually create an argument for property rights over data, but it recognizes the fact that databases themselves are an asset. The second important foundation of the NPD framework committee report's findings is that there is an imbalance in the data industry. And in the words of the report, data monopolies in India could lead to an imbalance between few companies and the Indian public. I paraphrase, but that is the broad, ambit of the report itself. And this is seen as an important commercial or economic purpose justification for putting in place some kind of a data framework. In addition, of course, there's a community privacy justification. The report recognizes the fact that non-personal data could provide collective insights that could open collective harms. So the fact is that, yes, that is true. As we discussed earlier, collective insights into the movement of members of community, or collective insights into the financial activities of a particular group of people, could open collective harms to that group. But the report sees the closing of data sets as a potential collective harm as well. It doesn't explain how the closure of those data sets is a collective harm, but it sees that it believes that this walling off of data is a collective harm. And therefore, it also puts in place the concept of collective privacy, which it seeks to protect through this NPD framework regulation. So, as I mentioned earlier, one of the important aspects of the framework is to create a basis on which NPD can be considered to be owned. As I mentioned earlier, public NPD consists of public non-personal data, consists of data sets which have been created by the government or which have been created under the aegis of the government. And accordingly, the report recommends the data sets have the character of a national resource. From that perspective, I guess the data set, this report is also interesting because it's putting forward the idea of an open data initiative, something which has been mooted in an open data policy earlier, and which, many kinds of organizations have been crying out for as a necessary, something which is required for the government to provide. And it seems to be laying the foundation for that. But the point is that that is one aspect of ownership of NPD under this. Community NPD is considered to be a collective or a shared asset of the community itself, which has been the source or the subject of the data. And therefore, the rights to that non-personal data are considered to be community rights. The community, as I mentioned earlier, could either be the source from which that data itself is collected, as in they could be engaging in financial transactions which are generating that data, or they could be the subject of the data itself, which is that they could be the actual focus of the study of the data. So, as a result of that, the framework report at least recommends that the concept of beneficial ownership be applied, and that's the legal fiction, so to speak, under which data trustees have been put in place in order to hold the community non-personal data in beneficial ownership. Private non-personal data is, of course, it was a good opportunity for the report to actually take a few steps forward into understanding or claiming of identifying some kind of ownership right in private non-personal data. But it doesn't take that step. It explains the way in which private non-personal data is considered to be shareable or non-shareable. So it says factual data pertaining to a community needs to be shared at no remuneration, and the algorithms and proprietary knowledge are not to be shared. But that processed data sets may actually be leveraged for data sharing on the basis of a mechanism which also will take into account remuneration. In order to put this framework in effect, one important final concept is there, that is the data business. The framework report identifies a data business as any kind of business which collects, processes, stores, or otherwise manages data and meets certain threshold criteria. They haven't defined those threshold criteria yet. Those are criteria which will probably pertain to the volume of data being analyzed or processed, or the capitalization of the company involved, or the turnover and such like. There would be any number of different criteria, but the attempt is to create the definition of a business that does this. The second thing which is important to note is that a data business is not a specific sectoral classification. It's meant to be a horizontal classification that would apply across all sectors. And from that perspective, certain large medical companies or healthcare companies would very easily fall within the definition of a data business, merely because of the volume of data which they would be collecting, processing, or storing. The report recommends that identifying a data business or a company being able to identify them, any entity being able to identify as a data business, should be open and discoverable. It shouldn't be a complicated undertaking to understand if you're a data business or not. But that such entities will be required to register once they reach a certain threshold. What's interesting is the report does say that this sort of identification of as a data business is applicable to the government as well. And I am not sure whether the scope of applicability is to merely public sector undertakings of the government or to the government as a whole, because then the requirements on data businesses or government data businesses would be quite significant. And it's important to note that these data businesses are required to compulsorily provide open access to metadata and regulated access to underlying non-personal data. Again, before we go there, let me just walk through metadata for a second. As I'm sure most of you are aware, metadata is information about the data being collected. So if you, I mean, from a very simplistic perspective, if you were to imagine data being collected as being collected on an Excel sheet, then a column titled name or a column titled age or underlying health conditions would be an metadata column. It is data about the data which is going to be on that feed. Of course, the concept is much more complex and takes into account a much larger and broader category of tags. But the idea is that data businesses need to provide every single data point of metadata that they are collecting. And that basically is supposed to enable the data sharing framework. Under the report, an authority called a non-personal data authority has also been envisaged. The report says that it examined the idea of placing this regulation within the ambit of an existing regulator, and it specified that within its examples, it would look at the Competition Commission of India, which is telling, and the Data Protection Authority envisaged under the PDP bill, which of course is not in place yet. But it realized, as per the report, it realized that a new organization requiring specialized knowledge needs to be able to identify the issues or deal with the issues involving non-personal data. The report is not necessarily clear on the composition or the powers of such an authority. There are aspects which are quite clear, but there's a lot of language which is focused more on the features, the selling points of a non-personal data authority, as opposed to the actual structure, powers, function, and authority of it. So it's supposed to be focused on unlocking the value of non-personal data. It's meant to be a proactive actor, unlike the CCI, which means that its role is supposed to be focused not merely on responding to requests or responding to any kind of request for inquiry, but proactively identifying ways in which data may be shared within the country. The non-personal data authority is also supposed to be able to evaluate the nature of data sharing requests, which I'll now get into in detail, to avoid unfair or spurious requests that don't serve these public, social, or economic purposes. And the authority should be capable of working with the PDP authority and the Competition Commission of India to ensure that important issues around data sharing, competition, collective privacy issues, and the possibility of de-anonymization are dealt with by each harmoniously. So in other words, the non-personal data authority is envisaged in the report as having not only an enforcement role, but also an enablement role in order to allow industries to access this kind of data. So broadly speaking, how does this framework for non-NPD sharing occur? If you are a company which has access to private NPD and you are identified as a data business, then you will have a requirement to place your metadata in a common database. This metadata database can be browsed by Indian citizens and organizations around the world. By Indian citizens and organizations around the country. And any citizen or organization can make a data sharing request to that company, to that business, their data business, based on this metadata. So if a company identifies that there is data pertaining to volume of traffic in a particular road, age of the drivers who are in that particular area, and let's say, for example, the office opening and closing timings around that space, then they could theoretically make a request in order to develop an application or an interface for senior citizens in order to travel at safe times on those roads. This is an interpretation of an example which is covered on board. Once a data sharing request is made, if a data custodian refuses that request, that is, if the company, the data business refuses that data request, then the data sharing request can be made directly to the non-personal data authority, which will evaluate, and if it determines that there is actually a benefit to the public, will order a sharing of this data. So again, it's important to note that the NPD authority here then steps into the role of an adjudicatory body in terms of determining if data sets are meant to be shared or not. Before I get into the international scenario, one thing I wanted to point out, the report has in place a very detailed system by which data should be made shareable. It talks about putting in place a number of different mechanisms, including APIs for easy sharing, and it talks about a detailed technical infrastructure. However, the areas which the report really needs to address would pertain to granularity with regard to exactly how private companies would be required to register as data businesses, exactly how large entities would be required to hand over data, and what kind of consequence they would be forced to face if they did not handle such data. What kind of the report doesn't necessarily address the question of whether a startup, which having been incorporated and suddenly having a certain amount of success and obtaining a reasonable amount of data, would be suddenly required to make that data available, which would actually result in a significant loss for a completely new entity which is trying to create a new space for itself in the market. The report also puts in place a bunch of recommendations for ensuring that non-personal data provisions are interoperable with the PDP bill. It recommends, as I mentioned earlier, that the data principal should have their consent obtained, as in should have, there should be a requirement in the privacy policy or other documentation which specifically asks the data principal for their permission in order to anonymize their data. Of course, the question here, which doesn't really get addressed in the report, is if a data principal is supposed to have rights over their anonymized data, once that data is added into a huge pool of aggregated databases, how will that data principal know which part of that data he's entitled to? Unless it just means that the data principal is entitled to view that aggregated database as a whole, because their individual contribution is also there. It's not necessarily clear coming from that perspective. The other provisions which are relevant is that there are key provisions pertaining to at least talking about data localization, and as far as those are concerned, they merely repeat the requirements under the PDP bill, which is that data should be classified as regular non-personal data, sensitive non-personal data, and critical non-personal data, with the first category being fully transferable, as well as of course being transferable and in and out of India. The second category being allowed to be transferred as long as a copy is stored in India, and the third category, which is critical non-personal data or critical personal data, being allowed to be retained, being required to be retained within India within Indian servers. The report actually mentions at Appendix 6 a number of initiatives for similar data sharing efforts, but in reality, there is no actual legislation in place, at least, which envisages anything resembling this existing framework. There is the Chinese cybersecurity law in June 2017, and the cross-border transfer security evaluation measures, which were instituted relatively recently, do place some very strong obligations on companies operating within China. But the focus there is on data localization. The focus on those legislations is not data nationalization. It's not on the creation of a framework for acquiring and sharing data sets. Similarly, the EU has regulation on the framework for the free flow of non-personal data in the EU. This was instituted in May 2019. But the primary focus on this was the aim to lift obstacles of data localization, not to create new ones. It addressed the fact that a lot of specific EU individual countries were creating data localization barriers as part of their municipal legislation. and it created an overarching legislation which required that these barriers within the EU should not exist at least. But aside from that, within the scope of legislation which is meant to address non-personal data and create a compulsory licensing framework effectively for the sharing of non-personal data, there is, at least to my knowledge, not so far any such thing. I'm going to stop here. There is a lot which can be talked about in the context of the report. It's not a large report necessarily. It's about 40 to 50 pages of main body, and there are about another 23 pages of appendices or so. But the primary concern is that there are a number of aspects of the report which immediately touch upon issues of community safety and security, of individual privacy, of companies' rights to determine their own data, and on the aspect of public and private property in the context of data. So I think there are a number of questions which we've already heard, which have been coming in, questions and comments. I think the best way to go forward on this would now to be address some of these questions and comments. Harish, is there anything you'd like to add on this?
Yes, just also to give you a break, Rohan, while you look at the questions, I think what is curious is I think we need to deal with two different realities, I suppose. Data collection in some form or the other will continue to happen, and I think we are now in a state where I think it's sort of romantic to assume that there will not be data collection, that there will not be any form of data collection. I think the way our societal relations are progressing, I think data collection in some form or the other will happen, right? And it will continue to happen, whether with so there are two issues, whether with our consent or without our consent, right? And that, of course, is a separate issue linked to privacy and the rules of engagement between the person whose data is being gathered and the person and the entity that is gathering the data, right? Now, I think most of what you have discussed is what is being regulated in turn once the data is gathered in some form, how that data has to be treated, how it has to be stored and shared with others is a question, right? And the metadata, should it be shared with everybody else, or should it be retained by the person who is putting time and effort into collecting the data in the first place? I think these are all questions that arise, and I think the report does talk about it. Now, the question we need to keep in mind is whether this kind of in terms of making available the metadata, which is anonymized to everybody else, will it sort of actually incentivize collection of more data, or will it sort of disincentivize people in collecting data, right? Because I think now the worry many people have had currently is because it's an unregulated sphere at the moment. People are collecting more and more data without actually knowing why they need it, or even when it is not required for the interaction between two people or two entities, you're asked to give more data, right? Now, this report, the framework report, will it incentivize collection of more data in any sort of interaction, even when the data is not required, and thereby creation of more metadata? Or will it reduce the amount of data that is being collected only to what is essential? Because I think if you reduce the data being collected to what is essential, then I suppose to some extent the metadata that is being collected in industry-specific purposes or purpose-specific collection, I think the ability to anonymize it and make use for it for everything may be reduced. Again, I think it is still something that people have not been able to wrap their heads around the entire scope. But it does lead to different different peculiar positions, and we need to see what kind of industry we see. The other question, I think, which I will leave today and for people to think about is, where should regulation start from? Should regulation start from the privacy end of stuff, from privacy end of data regulation, or should it start from, the commercial utilization of data? I think where you start from will, by and large, determine the nature of regulation that that we will see. And I think this committee report, I think, is trying hard to balance in terms of where it should stop. And I think it seems to be going the way of make it available to everyone for commercial usage. The question most privacy activists would ask is, why should there be a right to utilize data for commercial purposes? That's a different question altogether, but it's something that, I suppose the government will have to open up for discussion at some point. So I will stop there. Maybe, Rohan, you want to take a crack at some of the questions? I think there's a broad theme underlying differences between private and non-private, authority questions and things like that. So you want to take a crack at it first?
Sure, Harish. I'll read out the questions, and we can take a call as to which you prefer to walk through. But I'd like to just say one thing at first. It's a very interesting point on this. This is on. I mean, there's no way around the fact that this is a polarizing report, in the sense that if you are an entity involved with the processing of data, you are going to be either on one side or the other of this fence. You're not, it's a company which sees itself as coming out with a new business model and just requiring a data set in order to train that business model is going to be excited about a framework like this, because it's going to see itself as being able to have access to the same amount of data as the major data giants without necessarily having to collect it, but at the same time be able to create an algorithm or a product which will be trained at a much faster rate than it would have been done earlier. On the other hand, I would say companies which have spent significant amounts of time and investment and effort in protecting their data sets and ensuring that those data sets, have finally started working for them, because data mining requires a significant amount of mining. So creating an AI requires a significant amount of mining, and those companies are not going to be pleased with the idea of having to hand over all of the raw material they've collected in order to create generalized data sets for AI training. So, from a policy perspective, I think the report knows where it's coming from. It's identifying a way by which the access to data can be redistributed, but where entities come from is going to very much depend on how they feel about access to data in this manner. Okay, going from there, let me just address the questions individually. Let's start. Vikas has asked a question on a platform/B2B aggregator offering a free or freemium tech services to its subscribers and in return gathering data to design and offer services back to them or share findings, regulatories for betterment of a sandbox. Is this act of data gathering and processing amounting to community NPD? Yeah, so this very much depends on the nature of the tech services, the nature of the public forum to which, of the public which is making use of this data. And in the end, it could very well amount to community NPD, depending on the nature of the services and the nature of data being gathered. See, that's one of the problems with the definition of community non-personal data. When a large ride-sharing company collects data about which people are traveling to which localities in which city, that is clearly going to end up becoming community non-personal data, insofar as specific communities live in specific parts of specific cities. It is not avoidable. Similarly, if you have data regarding the financial activities of specific districts or specific localities, the fact that those districts or localities may have a larger preponderance of specific communities is going to identify specific traits about the communities in there. So yes, in answer to your question, it could amount to community NPD. It entirely depends on what kind of data and what kind of services are being offered. I hope this answers your question. Shailaja. has asked about the difference in private non-personal data and community non-personal data. This stems from the fact that community non-personal data clearly states it does not include any private non-personal data. How is data collected by a telecommunications provider classified as community non-personal data? No, so just to clarify on one point there, community non-personal data does not necessarily exclude private non-personal data. As I mentioned earlier, like, let's get off ride sharing for a while. Healthcare companies may collect completely aggregated blood pressure data from communities all across India, or from people all across India. They may establish certain geographical trends. They may establish certain community trends. They may establish any number of those. Those will be classified as community personal data, community non-personal data, I think, is what you mean to ask. And in that context, at least the fact that they are collecting that data is required to be reported in the form of sharing the metadata with the under the framework, essentially. So the difference in private non-personal data and community non-personal data is that in general, private non-personal data pertains to non-personal data collected by private actors, and it's best juxtaposed with public non-personal data, which is collected by or under the aegis of the government. But community non-personal data is a subset of both, and its treatment is going to be a complex issue under this report, under this framework. Okay, so we have one more question from Shailaja, which I'll come to after addressing Nishant Prasad. Nishant, in terms of collective harms based on NPD, for example, if you have data on pubs or bars or other places where, say, gender or sexual orientation is taken as a community data, access to such data can create a bullseye as a target for areas which are frequented by members of certain sexual orientation or even a religion or a caste, etc. It may create ease of planning for targeted attacks in certain communities. Is there any protection in the framework on these aspects? To be fair to the framework, it does acknowledge that this, and in fact, using some of the exact points you've raised, it acknowledges these as potential threats to communities which can arise from an exploitation of community non-personal data. But at this particular stage, at least, the framework is very much a framework. I would distinguish this report from the Sri Krishna Committee report in that, short of actually drafting out an entire legislation, which it also did, it put in place almost every single every single talking point you need to think about in order to address the complex issues involving personal data. Here, there are a lot more talking points which need to be addressed, a lot more concerns, and amongst those are the concerns you've raised. What is the actual scope of protection for these aspects? The report definitely recognizes that there's a need for protection, but I would say it has not addressed the mechanisms by which this protection can be either prevented or redressed if there is an abuse. Then we have a question from Anushri Kapoor. Is the non-personal data authority or the data trust, or are they different entities? It's understood here that they are supposed to be, well, they are understood as two different kinds of actors. I don't know if under certain circumstances the non-personal data authority may end up becoming data trust, but the data trust itself, sorry, I think you're asking about the data trust and the non-personal data authority. My apologies. A data trust is a different entity itself from the data trust. It's not necessarily even an actual legal entity. The data trust is the database into which, or the data, maybe even the databases, the data trusts, maybe the databases into which different forms of NPD are funneled in order for them to be redistributed under this particular framework. So the non-personal data authority administers various aspects of this framework legislation, this proposed framework legislation, including data trust, but it's not a data trust. So Sharanya has a few questions. A lot of companies scrape data from other websites. Would that be under the community NPD? In that case, the report is silent on what community NPD is. Yes, I think we've covered that aspect. That it is something which is a bit nebulous. The second question is that the PDP provides for constitution of authority, but the report mentions it would be a different authority for the NPD. Is this practical? as a matter of, I think, there are a number of questions which people ask, is it practical? And only when it finally happens, they find out if it's a practical implementation or not. The report envisages that the NPD authority should be able to function harmoniously with the data protection authority under the PDP bill. But we'll have to see how that works out. You mentioned that the NPD authority can be an enforcing authority, but doesn't provide any pecuniary, and I think you mean penal measures as well. What would be the punishments for breach? I mean, honestly speaking, I think the underlying question is whether a framework of this nature needs to exist and how it needs to exist. But presuming it does, the kind of breach which could occur as a result of violation of community data, I don't even know if it's the kind of breach which can be remunerated in the form of damages or money. I would say that that if there is an actual attempt at trying to regulate access to community data or private data in this format, we need to see the legislation from a completely different perspective, not merely damages / penalties legislation. And I agree that there's a lot more thought than what we have right now on the subject, at least. You mentioned that the PDP bill spoke on data localization. Would the NPD report look at localization? Yes, the NPD report has looked at data localization. It has addressed the question of data localization. As of right now, it has basically made recommendations similar to that of the PDP bill. So while there are broad-based recommendations, they have not gone into a significant amount of detail. They have addressed the question of whether NPD should be localized or not by equating that with personal data under the PDP bill. Aman Sinha asked whether vehicle data like that from sensors can be covered under the ambit of non-personal data. Also, the report says something about ownership of data gathered by functions like emergency call features. Yes, so the first aspect is absolutely correct. Vehicle data like sensor data can be potentially covered under the ambit of non-personal data. Of course, with the connected car situations we have right now, where you have smart vehicles which collect incredible amounts of data about their drivers in its non-aggregated form, this data is very much personal data first, and only when anonymized can you consider it as non-personal data. So yeah, I would say that that this potentially could be within the ambit of non-personal data, but only after it's been anonymized. Ownership of data gathered by functions like emergency call features, it doesn't directly address that. I would definitely see that something which is a concern and needs to be addressed on a specific case-by-case basis.
Rohan, we have time for only one more question.
Oh, okay, all right. So I have a question from Rupali on the conversations around community. Who decides the groups that constitute a community, and are communities defined under any other law? That's a good question, and it goes to the core of what I was saying as an IP lawyer. My connect with issues regarding the definition around a community or the groups that constitute a community arises from geographical indications, and there has been a significant amount of litigation between different community groups over trying to identify who is the custodian of that community's rights to a particular geographical indication. And I would anticipate that there's going to be a significant amount of debate on that issue. Whether communities are defined under any other law, I would say that at least the question of who is the custodian or the trustee of that community has been debated under other laws, or at least under other case laws. And I anticipate that's something which is definitely going to come up again in the context of this data. Harish, there are a bunch more. What should I do?
I think maybe you can take one more. I think there's a gentleman who's asked 2 questions. Maybe you can take both those together. I think Gayatri's question is, it's a fair question. Why do you need a separate authority for personalized private data and then non-private data? I think it's a fair question. We will see how we go on that. But I think why don't you take Yavar's question, one of Yavar's questions, and we can stop after that.
Sure. So Yavar, you've asked if an IT company collects data of farmers' milk supply to other dairies. What is the extent of impact which is involved? I'm sorry, Yavar, I'm trying to, okay, if the IT company collects data of farmers' milk supplies to other dairies, okay. I would hope that you'd be able to just maybe clarify a little bit more, Yavar. I'll look at your second question in the meantime. Who will be the data trust and data trustee in the case of a farmer? Okay. a farmer who supplies milk to dairies. Okay. Yeah, thanks for further clarifying that. So, okay, yes, the community of farmers who are supplying milk to dairies is probably an identifiable community. They would tick the boxes required. If an IT company collects their data, then they would be the community of farmers would be the data principal. The data custodian would be the company which collects that data. The data trustee would be any representative body which deals with the rights of that particular farming community. And in the absence of an actual organized entity of that nature, it could end up being a branch of the government. And this, of course, does raise questions about to what extent or the other the government would be able to represent their concerns effectively, depending on how small a community they are and what the issues would be. Not for any other reason. It's just that the government has a lot of things to do. So it's going to be a complicated thing to figure out. So if an IT company collects such data, if it's anonymized data in the current framework which we have, there is actually not. If it's actually anonymized data, there is actually not much. So from that perspective, the report is actually asking an important question in terms of what shall we do about the situation where large scale rights of communities are being exploited in this manner. But how to answer the question is a good point, basically. So yeah, I'm not sure if I perfectly answer your question, Yavar, but I think you get an idea of the kind of issues which are going to come up in this context.
Yeah.
Okay.
I think we'll stop there, Rohan. I think thanks for taking us through the report.
Thank you.
It was very insightful. I would only sort of say we should watch this space closely, because this is a contested space in many senses. And earlier it used to be a contested space between people who said data should not be collected without consent and how data is collected. So there's a lot of focus on that. But now I think this report also opens up debate on the rights to use this data, and what is the right of the person who collects the data or the entity that collects the data, and the right to use that data for other purposes. And can there be a distinction between different kinds of purposes? Now the question, of course, I would like to end by pointing out one thing. There have been many people comparing this with land, and how the government has right over land, and therefore similarly the government should have the right to regulate data of its own people. I think there's a fundamental distinction, in the sense that particularly after the right to privacy, I think there is no right. The government does not have a right to regulate data. I mean, in the sense that the government does not have a right to say, I own the data of my citizens. Right? The data of the citizens is still owned by the citizens themselves. So I think that this important distinction we should remember. Unlike land, and where there is a constitutional framework around land, and data privacy is now recognized as part of Article 21 and part of the fundamental right. Therefore, it's a bit more complicated than that. So we'll stop on that note. It's an interesting space to look out for, and I'm sure we'll have many more discussions on this in the future. So thank you, Rohan, and thanks everyone for participating. Thank you.
Thank you, Harish. Thank you, everyone. Thank you for your time.